So the topic is legal guidance for SMEs, and they gave me a full 20 minutes for this. It's an impossible task. I decided to focus on two issues quickly. The one is contracts or agreements, and the other one is bad debts or debt collections. Just a bit of tips there. Everybody struggles with that, obviously. Please note there are many other things when we talk about legal guidance for SMEs, things that are relevant to SMEs that we cannot touch on now: employment affairs, trademarks. Yeah, so I'm not going to try and list all of that. Let's just quickly have a look at a couple of things, a couple of mistakes that SMEs make. We've spoken earlier about the business structures, and we often find businesses are in the incorrect structure. Agreements are not put into writing, and we're going to be discussing that at more length later now. We don't have employment contracts or policies in place. We don't protect our IP. We don't protect our ideas and trade secrets, and we allow bad debts to escalate. So why is that? Mostly, we've identified the following principal reasons: is that legal services are expensive. When you start up, cash is strapped, and to pay somebody to give you advice on something that doesn't seem to be necessary or doesn't seem to be a problem doesn't make sense. So we rather prioritize our cash for the operations and maybe expanding, paying creditors, obviously. Another big problem is that we simply don't believe it is necessary to put agreements into writing. And that's usually because when we're making a deal, everybody is excited. Everybody wants to work together. Everybody wants to make this deal work. And there we go. And then we didn't go through what I call a proper drafting process, and we'll be discussing that. Sometimes we just don't know what we're doing wrong, or that what we are doing is in fact wrong or can create problems. And all of this is usually made worse by the fact that we're not connected to an attorney, and that is because it's perceived to be expensive. Let's look at agreements quickly. The first major thing to keep in mind when you're doing any agreement, and that ranges from simple agreement, a simple transaction, buying and selling a car, to more complex things, buying and selling a business or shares. There needs to be an offer, and there needs to be an acceptance of that offer. So usually these things start out in an email. I will send an email with my proposal to somebody, and they will come back and they will say, yes, that sounds like a good idea, but, and then what follows is not, it's not an acceptance of your offer. That is actually a counter offer. It's a new proposal, and you need to accept now what they have put on the table. So you need to be sure always that there is clear indication of what is offered, either what you are offering or what is being offered to you, and a clear and an unconditional acceptance of that offer. If there is a condition involved, it needs to be noted. You need to know that there is a condition. Otherwise, the contract hasn't come into effect yet. It's only at the moment of acceptance, unconditional acceptance, that there is an agreement. An offer can be withdrawn. So you can say, this is my proposal, and I want you to buy my car for 400,000 Rand. And before it has been accepted, there is no contract, so I can withdraw it. Unless I say, you can buy my car and I'll leave this option open to you until close of business tomorrow. Then you have indicated, you've given an undertaking that you cannot withdraw that offer. There are some formalities that we're going to look at. And then I often get the question, but can we agree on this? Can we do this? Can we put this into our agreement? Those are all, usually the rule there is you can agree on anything. You can even agree to something that is at your prejudice. The courts do not necessarily stop an agreement because it is bad for you. It must, however, be lawful, of course, and it must not be against public interest, or actually public policy is a better word of describing that. In order to have an agreement, you need to offer an acceptance, but certain essential terms need to be agreed on. So if I'm going to buy your car, it's not sufficient for me to say, I want to buy your car, and you say, you may buy my car. There's an offer and an acceptance, but the terms aren't sufficient to constitute a valid agreement. For instance, in that example, a price is essential. If we don't have a price, you can't enforce the sale, and I can't enforce it either. If we agreed on the car and the price, but not on a date for delivery, that's not a big problem. We've agreed that I am going to buy your car at a certain price. The timing is something, if it's not agreed on, the courts will allow a reasonable time after concluding the agreement. I'm not trying to give you solid rules, I'm trying to explain principles. So when you go into an agreement, you must be sure that you explain or describe enough detail in your proposal, and that must for them to accept. A lease agreement, obviously the property will be very relevant, the rental, and I would say the term of the lease would also be something that is important. In an employment agreement, the identity of the employee is an essential term, while in a sale of a car, the person who is selling the car is not an essential term, except in as far as it relates to ownership of the property. The golden rule, and this is something that I'm going to repeat a couple of times because I want you to really understand and to remember this, is that the more detail you have in your agreement, the lower your chances are of having disputes later on. Formalities. You've often heard that it's not signed, the agreement is not signed, so it cannot be enforced. That rule only applies to certain specified classes of agreements. The most important one is buying and selling property. Renting property is not the same, but buying and selling property, if both parties did not sign a proper sale agreement, that cannot be enforced. Then there are some formal or legal agreements that also need to be in writing: a franchise agreement, a suretyship, credit agreements, employment agreements. Your will, your testament must be in writing, and there are some other formalities that apply to that. If it's not in writing, it cannot be enforced. So be careful of when you do an agreement to make sure that is it a formal requirement for this type of transaction to be in writing or not, and if it is, make sure it's done properly. So if buying and selling a car, for instance, or we spoke earlier of selling shares to a new shareholder, if those agreements aren't required to be in writing, why do we put it in writing? Now that's very simple. The more terms and specificity we have in a written agreement, the less likely we are to encounter disputes. I always say, if you have an agreement, you're probably not going to use it. But if you don't have it, you're going to wish you had one. Why is that? If you go through a proper drafting process, if you came to me, I would tell you, okay, you told me you want to buy a car, but what if this happens? What if this happens? When must this happen? Who must do this? Etc. So you go through a lot of, and the more complicated the transaction, the more what if scenarios you have to go through. And then you deal with those scenarios in the agreement. You will create a clause in your agreement to say, should the following occur, the parties agree that this is what will happen. Now, if one of these what if scenarios actually occur at a later date, you will find there's no dispute, there's no problem. The parties might not even find it to be a problem because we've already discussed it. We've already agreed what we're going to do if and when this occurs, and we just simply continue, and the deal is not compromised by this occurrence. Termination of an agreement. Obviously, the two of us can come together and say what we agreed previously is not working. Why don't we rather terminate it? That does not always need to be explicit. It can be implied, but once it's implied, again, it's not clear, it's not in writing, and there might be disputes thereof. You might have a fixed term contract, so you're going to rent my property for a year. After a year, that agreement lapses. And sometimes we'll say, I'll use your services for as long as I want, and I'll let you know when I don't need it any longer, and then I can simply terminate the agreement by notice to you. When somebody breaches an agreement, you can also terminate it. It's not always necessary to terminate it. Sometimes you can enforce specific performance, and there's the option of claiming damages. So specific performance is not always an appropriate remedy. If I'm going to buy your car, that's easy. I don't need you to like me or to live in peace with me afterwards. I just need your car and then I can drive off. When my fiance breaks the engagement, specific performance is not going to be a great solution there. I cannot force her to marry me. And even if I could, that's not going to go well for either of us. Then just a little bit of a caution. If you're in an agreement, and for instance, you're supposed to deliver some products, but you get into a fight with the other party, and you might, in a moment of anger, say, I will never deliver my product to you again. That could be construed what we call a repudiation. It's an indication that you do not want to be bound by the agreement any further. The other party can then decide to either cancel the agreement. He accepts your repudiation and he cancels the agreement, which means there could potentially flow damages out of that, which you will be responsible for because you're the reason for the cancellation. And otherwise, you can reject your repudiation and request or insist on the agreement to proceed. So just be careful that you don't say things like, I don't want to be bound by the agreement, because it could have consequences that you didn't anticipate. So bad debts, this is a headache for each and every one of us. And SMEs, we find, are often, they struggle with this a lot, because when there is a deal on the table, you have to accept it. You're building a business, you cannot say no to any business that's coming your way. And you often take deals or transactions that are not secured with regard to payment, and then you end up with a very large debtors book. So what do we do? Once again, first of all, if you have a proper agreement in place, you are a couple of steps further to not having problems with the client. It doesn't always need to be a complex agreement. It doesn't need to be a thick 50-page agreement. If you're selling stock, you can have standard terms and conditions. If you are rendering a service, you can have standard terms of engagement. It simply puts down the basics. Even if it's only the basics, it's going to help you a lot more as opposed to having nothing. Obviously, we all want cash on delivery rather than credit, but it's not always possible. If you have to give credit, obviously you can incentivize cash payments and so on, but if you have to give credit, once again, I have to stress this, have a proper agreement in place. And then something that is very useful, not always very popular with the debtor, but is to have some sort of a surety or a security. And I'll talk about that a little bit more later on. Then you also need internally a system and a process that you follow in case a bad debt will arise. So we get a lot of clients that come to us and say, this person is not paying me, will you please issue a summons? And then we can see that internally the right steps weren't followed. Now there's no formal requirement or so, but some things work better than others. So we start off by having a proper agreement that tells that client what's going to happen if they don't pay us. And it enables us to, it will help us in the litigation process. There will be a clause to say, you'll pay my legal fees. I can go to the magistrate's court rather than the high court, which could have a lot of cost implications, etc. And then hopefully we hold security so that we know that if the guy doesn't pay, we can go after the company and the director or the shareholder, whoever signed surety for us. And then you need to start following up on those creditors regularly. We always say that the squeaky wheel gets the oil. If he's not paying you, he's probably not paying a number of other people So you need to be ahead of the pack, and you need to be the one that he wants to quiet down. So make sure if you leave him and he says, I will pay you, you leave him for 3 weeks. In those 3 weeks, he's paying other people because they are irritating him, and he needs to get them off his back. So you need to be on his case all the time to make sure that you're in front of the line. To charge interest, it is possible. It's a bit of a longer conversation, but it's not a National Credit Act problem for you if you charge interest on arrear accounts. It's called incidental credits, and you're allowed to do that, but it incentivizes your client to pay you quicker, because if there's no interest, then there's no stick that motivates him to pay you quicker. And then if you've struggled with a client for a while and you've had the same excuse once or twice, then you must consider handing him over. There is a cost implication handing over clients to or your debtors to an attorney. But if you take too long, the business could go under. Then you don't have anybody to enforce that debt against. They could move premises, then it's difficult to find them, etc. So it's much better not to wait too long before you engage an attorney. Keep in mind the debt must be enforced within 3 years. So if I definitely don't want you to wait 2.5 years before you hand it over. But if you were to wait 3 years, then it's prescribed, and then you can't enforce that debt. There's no way of enforcing that debt. I've mentioned security. There are a couple of options for you. The first and the easiest one, if somebody's going to buy on credit from you, is just to make sure one of the directors or all of the directors, maybe a shareholder or somebody that hopefully you will know, or you can ask them to show you that that person has some substance, for that person to sign surety. That means that person will be liable towards you for all the debts of the company as well. Cession of a book debt, that is a nice way of collecting debt where, for instance, you're a subcontractor. The employer is the municipality. He's appointed a main contractor, and the main contractor has drawn you in as a subcontractor. Now he's not paying you. Then you say, give me cession of your claim against the municipality. And then you go and tell the municipality, listen, I've taken cession of the main contractor's claim against you. When and if, maybe might also be appropriate with municipalities, you pay or you have the funds available to pay the contractor, you shouldn't pay him. You should pay me instead, because I've taken cession of that debt. A pledge is very much the same. I don't think anybody uses checks anymore, but a post-dated check, it's a liquid document. It's very easy to take judgment when you have a signed post-dated check. And then for the larger debts, you can do it for small debts. There's a notarial bond and a mortgage bond, but it's too expensive. So usually only when you get into larger debts. Notarial bond is registered over movable property. It's a bit of a difficult thing because you have to enforce it through a court action and so on. So it's not great, but there is some measure of security there. And obviously a mortgage bond is excellent security because there's a property, it's registered in the deeds office. You know it has value. And nobody can sell that property without first canceling your mortgage bond. It's like whenever you take a loan to buy a property, we all know the structure of a mortgage bond. So that's very good security. That's why the banks accept that for your home loan. Just see. Yeah, I think that is about my time. Like I did say, I've asked them to distribute my slides for you, especially the previous one where a lot of the detail wasn't covered. But I'd like to remind you of our online service, SME Legal. It's where we make a lot of agreements available, where you fill in your variables and then you can download a PDF agreement instantly. And it's an annual fee and you have unlimited use of the resources online. It's a way that we've created to try and help SMEs to avoid the high costs of legal services.